147, People versus Walker. Cassidy, what any rebuttal time?
2 minutes for rebuttal, Your Honor.
Go ahead, John.
May it please the Court, Tim Hoover of Phillips Lytle, counsel for appellant Chris Walker. In this defense of other case, the delivery of the form non-mandatory CJI initial aggressor instruction was a misstatement of New York law, confused the jury, and is reversible error.
How did it confuse the jury?
Judge, well, first of all, it was inaccurate, and it allowed the jury to convict on at least one of two erroneous bases. First, the jury was told they had to decide who the initial aggressor was, and they could conclude that Mr. Walker was, even though he couldn't be under New York law. The second,
meaning if he's a good Samaritan, even if he was the initial aggressor, it's a different situation.
Correct. New York's not an alter ego state. The Court has Judge Jones'
So if he believed that someone was whoever it was in imminent danger, if that was his understanding, that would have been okay. And you're saying that the charge doesn't make that clear at the very least?
Absolutely. It doesn't explicate as the CPL requires it to the appropriate legal principles. And we get that from Judge Jones' decision in Melendez. We get that from the People's Brief and concession at page 12, where they say the initial aggressor is never the intervener. The limited application, and I'm referring to Judge Jones' decision so much because it's the lead decision.
What about the case, counsel, where the intervener was there at the beginning of the altercation and saw what was going on, or maybe should have known what was going on, and then jumps in? Does that make that person the initial aggressor at that point?
It makes it doesn't make them the initial aggressor, but it makes the concept that they're not legally allowed to, or they're not justified in intervening in that circumstance. That's, as Judge Jones says, the extremely limited application is that the intervener was present or initiated the contact at the outset or had reason to know. So in your question, the intervener would have had reason to know and wouldn't have been privileged to intervene. In addition, their actions wouldn't be reasonable, which is the touchstone. But getting back to the second way it allowed the jury to go astray, the people made very clear here that they wanted exactly what I'm talking about, these two theories, to go to the jury. They argued in avoiding the trial order of dismissal at 518 of the appendix that if the brother was the initial aggressor, then Mr. Walker would be guilty. But they also paired it with this acting in concert theory to make clear, really it's kind of code for alter ego, that look, if one of the two people, the brother or the woman that were on the porch and part of the initial scene or fight, which, by the way, no one says Mr. Walker was part of, different from your question. If one of them was the initial aggressor, look at this look at this acting in concert language, and you can use that to convict. And that's what the ADA hammers home in closing at page 616 of the appendix. It says, consider this initial aggressor defense. Of course, it's not a defense. It's an exception to the applicable defense. How did the argument begin? How did defendant and his accomplices get on the porch? So the people got the best of both worlds. They got this instruction that was wrong on the law, and then they paired it up with their acting in concert theory to lead the jury astray with no different explication.
I lost you, because in reading the charge and knowing, how this whole thing unfolded, it seemed like, he's coming there to defend his brother, right?
Absolutely.
All right. But all of the testimony was that this guy, this 60-year-old guy, was, they were kicking him off the porch and everything else. Doesn't all that factor into what the judge is ultimately going to charge?
It doesn't let the judge charge initial aggressor in defense of another because the concept has no legal applicability. Now, the other facts, and by the way, many of the prosecution witnesses say they didn't see Mr. Walker kick him after the fact, and the person who the decedent here had a blood alcohol content of 0.19, was high on cocaine. There was testimony that he had a hammer, which is why Mr. Walker comes down the street to intervene. But all of those actions, Judge, go to the reasonableness of the intervention, the idea of defending another. It has nothing to do with the initial aggressor concept, which the jury is told directly after, and this is at 646 of the appendix, they're given the general justification principles, and then they're told, but if he's the initial aggressor, he can't be justified. There's no defense.
Are you saying there's no way to construe the evidence to establish that he was the initial aggressor?
I'm absolutely saying that, Judge. Both because of what New York law is and because there's no way to construe that he was not part of, so both, he was not the initial aggressor, he didn't initiate the fight, and there's no testimony that he was present at its inception.
Right,
but he doesn't have to be an intervener to be present at the initial inception. And that's why, see, the justification defense, the charge that was given was exactly what the CJI has, and the initial aggressor language. The real question for us is, should that language be changed if that language is wrong, and then are you entitled to a new trial as a result of that? To argue that the trial should be thrown out is an entirely other issue, I think.
I guess I would disagree. So it is the pattern language. Judge Jones' decision says the language was incomprehensible in that grand jury context. The New York City Bar Association says, going back 7 years after the trial, but fairly shortly after, that the language doesn't appropriately state New York law. It's inconsistent.
So could there be an explanation on the language beyond whatever the standard language is that would have made this okay?
There absolutely could. So our request, the request was don't charge it. The judge did charge it. On remand, the trial judge, under the court's guidance, could not charge it, or as long as the statement of law is accurate.
Straightens out.
It straightens out, which would be something along the lines of the defendant is not the initial aggressor with regard to assessing defense of another.
That's from losing it. I get that the two that went to the store first and came back, were the initial aggressors against the victim here. But does that mean that once that happens, there can be no other initial aggressors, in your view?
As far as defense of another, that is what I'm saying. There's only one, and this is the People's Brief at page 12, there's only one initial aggressor with regard to a defense of another scenario, and it's one of the original.
There could be two ways. One is a subjective way. He comes up and says, yeah, I'm going to help my brother beat on you. This is the guy with the hammer, Simmons, who's killed. Or another one says, you're beating on my brother, stop. And you're assuming that he was the initial aggressor, which he has a subjective right to do. That's what the charge should say. And that, therefore, the justification defense applies, and he doesn't have the initial aggressor problem.
I agree. And your first scenario, he ultimately is not justified because his actions aren't reasonable. There's a fight where, my brother's beating on you and I'm going to jump in.
Justification defense doesn't apply to the first scenario. He loses on that. But in the second scenario, if he subjectively believes it and objectively, if a reasonable person would believe it, then that initial aggressor exception would not apply to his justification.
I agree.
That's your argument, right?
That is my argument. And, the judge, the trial court has an obligation under the CPL. It is a form pattern instruction. This court has reversed or vacated verdicts. And if I could finish, Judge, I see my lights on.
Finish your thought.
It's not necessary. We have an inaccurate statement of the law that's confusing. This court, and it's a 2007 case, Boyd, a civil case, Judge Smith, there the form instruction was accurate. It wasn't legally wrong, but there was still the possibility of confusion. Here we have inaccuracy, confusion, the jury not getting the right legal principles.
Okay, Counsel. Thanks, Counsel. You have your rebuttal.
Good afternoon, Your Honors. May it please the Court, Jeffrey Court for the people.
Counsel, why isn't it confusing in light of the Good Samaritan law?
Okay. Well, if I can...
If he comes and to his knowledge, he's acting to protect his brother or whoever it is, wouldn't that charge that was read provide a wrong view of the law to the jury?
No, and I think
does it matter if he's vis-a-vis his role as the Good Samaritan? Mm-hmm. It doesn't matter whether he's the first aggressor, does it? Whether he takes the first.
It matters whether he's the first one to use deadly force as opposed to. That is, you can intervene in
the brother is in imminent danger.
If that's the case.
Assume that's the case.
Sure. Yeah. No.
How does that charge guide them? The jury.
Right. there's one initial aggressor in the encounter. There's one initial aggressor, or two, depending on non-deadly versus deadly force. But I mean, the defendant keeps trying to make this something you have to view in binary.
Before you go on, what do you mean by that? One, if there is deadly force, or two, non-deadly force. What if there are two deadly forces? I guess you can't have that unless both people get killed, but what if someone, the person who is already on the scene is like this, in this particular case, has got a hammer, and then the intervener comes up and he's got a weapon too. So what do you say there? Is that two aggressors or one?
There's one initial aggressor there, one deadly initial aggressor of deadly force, and under that circumstance, which would be if the jury had bought defendant's testimony, right? That I come upon the scene where this guy is hitting my brother with a hammer. At that point, the defendant then is not the initial aggressor. But there's a reasonable view of the evidence here.
Yeah, but does the charge allow the jury to understand the law in that exact context that you're talking about?
Yes, because the defense requested that language from McWilliams, and the court agreed and gave that. And that gets me to...
Don't you think there needed to be a clarification in the particular context that we're talking about now, assuming the other guy is using the hammer, he thinks brother is in imminent danger. In that circumstance, doesn't the judge have to explain if that's the case? It's a little different scenario.
I think the judge's
given the Good Samaritan law.
I think the judge's instruction is correct on the law on that point. That is the confusion. If I can explain what I think the confusion that the defendant is finding is created, which is something that's not in the statute at all. It's not in the instruction. And that is this idea that initial aggressor has to be something you do in a binary thing. So the defense says, well, they don't know, is it initial aggressor vis-a-vis the victim? Is it initial aggressor vis-a-vis the third party? That has nobody would be confused by that because there's nothing in the instruction that would lead you to think that. The statute would then have to say, unless the actor is the initial aggressor as to the victim or as to, or, you know, it says nothing about that. It says the defendant can use the justification.
But isn't there a difference between a three-way kind of situation and a two-way situation?
Factually, it changes how you apply the law, but it doesn't change the law.
And you don't think that's confusing to a jury?
I don't think so. And I think the proof here is the fact that the jury wasn't confused with it. They were able to ask, they were confused about intent.
Maybe they were, and that's why they came out the way they did.
I think that, I mean, obviously we don't know ultimately, but they asked no question about this. Whereas they asked, you know, wait, with intent, at what point do we have to measure intent? If they were sitting there thinking as a defense, oh, do we have to measure initial aggressor against the victim or third party against the victim? Or, you know, presumably they're going to ask a question about that.
Maybe they didn't think there was any problem.
Yeah,
They just said, first aggressor, that's it, doesn't matter.
I think we can assume that they understood the language in the ordinary sense of what it was, which says nothing about some sort of binary, singling out a binary relation.
That's the point. The ordinary reading of it would be, oh, he's the first aggressor. That's the end of the story.
No. A normal reading of the charge that the judge gives is if he's the first one to come in with deadly force, then he's the initial aggressor. If he's the first person, if he comes in to a situation where there's already deadly force being used, then he's not the initial aggressor. That's the factual issue that the jury is wrestling with. Is ultimately the question of did the victim have the hammer or, you know.
I guess, Mr. Nover, the problem I see in the way the charge is written now, and I agree with you that Judge Valentino read the law as he thought it was. It wasn't like he misread it or anything like that. He read the way the CJI charge is actually written. But it seems that in this situation, that the initial aggressor, we don't know objectively whether or not Simmons or the brother, whatever his name was, were the initial aggressor. Let's assume we don't know. The brother comes up and may subjectively believe that his brother is being attacked and was not the initial aggressor, be justified in his belief if an objective person would come by and think the same thing. But the way I read the charge is the judge doesn't set out that three-prong analysis. And And I think it's, in looking at it, I'm concerned that the charge itself is defective. Not that there was some defect in the trial of the case or they went to the wrong charge. I don't see that here. What I see is the charge itself is more of a concern.
Well, I mean, I think the charge accurately states the law, but if I can make a different point, if you're,
Go ahead.
And that is that this is absolutely not preserved. There is no question this is not preserved. The defense makes an argument, I want no initial aggressor instruction. The court says, no, I'm going to give an initial aggressor.
Does he say it's confusing?
He says it's confusing, but
So what else do you need to say?
you have to say, and I want you to add something. And what does he do? He says, I want you to add something. McWilliams. And the judge says, okay, I'll add that. There's nothing else asked for.
What would the judge think when he's saying that it's confusing?
Exactly what the defense is saying. It's confusing, so I don't want you to give it.
What would the judge think he is saying? Just that the charge itself is not dealing with this issue that we've been asking about?
Absolutely not. Absolutely not. The question is, I want you to get the initial aggressor instruction out entirely. I don't want you to read it.
How much do we stretch the preservation rule where that I don't think the average person would think he's confusing because that charge that's in the CJI is confusing. This is a complicated event that's happening.
Didn't the defense counsel, after the court said it was going to give the initial aggressor charge, say that any language regarding initial aggressor should be omitted entirely because he was concerned about whether or not there would be confusion as to which person that they need to look at in terms of being an initial aggressor? That's exactly what he's arguing now, isn't it?
No, because now he's arguing you should have added something in to the charge, which he never asked before. He never said, I want you to give a further clarification.
The only way he could have preserved it was not to say I don't want it at all, or not to say it is confusing, but to say I want you to modify it, and here's the language I want you to put in.
Yeah, it's confusing, so you need to do something. But not confusing, so, I mean, he says it's confusing, so you need to clarify with McWilliams. That's what the court does. So the judge didn't just...
And if he had requested that and the judge had made some other modification, would he then preserve his position because he didn't get what he wanted? Or does he then again have to say, that doesn't work, I still want the McWilliams language?
If he asks for specific relief and the judge gives some other relief, I mean, I guess that gets a little hairy. I would think probably if you request the relief and the judge denies it, that's preserved. He didn't request this at all. Very definitely did not ever ask the court to give further instructions, never mentioned Melendez, never said anything about.
You don't think that the judge gets the point as to what, he's complaining about?
I think the judge does get the point. That's what he's saying. He's asking.
That's not preservation.
No, he's asking, I want you to not read the initial aggressor instruction at all, or I want you to read the initial aggressor instruction plus McWilliams.
But it's telling him exactly what's confusing about it.
Well, but he can, I mean, making an argument in which you say something's confusing doesn't preserve any argument that would also rely on something
Pretty
that's confusing.
strict view of preservation.
I think it's exactly what's in 470.05 sub 2. You have to direct the judge to what you think is the error. He doesn't just...
You don't think he directed him to what the error was?
No. I mean, he says you shouldn't have the initial aggressor instruction at all. He says if you're going to have it...
He explains that you can't tell in this context.
So he can ask, if he wants to ask, I want you to clarify this, but he absolutely never does that.
He had to come up with his own charge, and instead he came up with just add McWilliams.
Yeah. Yeah. I mean, that's what he, well, I mean, he could, I mean, he doesn't even necessarily, I mean, he could even just say, Judge, this is so confusing, you need to add something. Even if he said that would preserve it. But he doesn't even say that.
Okay. Thanks, counsel. Your rebuttal, counsel.
As Judge Stein alluded to, this is the gold standard of a preserved objection to a jury charge. So on the Friday, while they're having the conference before the February holiday weekend, the defense counsel doesn't just say stuff. He hands up the charge he wants without the initial aggressor language, which is exactly what we're arguing on appeal. The initial aggressor language should not have been given in defense of another, 545 of the record. He makes his legal argument at 558 of the appendix. They come back over the weekend. And by the way, no doubt here, everyone agrees that defense of another had to be charged to the jury. The trial court marks it as 569, Court Exhibit 1. Further argument by defense counsel about why you shouldn't give it. And then the trial judge says at 574, it's preserved for the record. I understand what you asked me to do. I'm not going to do it. And then, by the way, McWilliams is a separate part of the pattern instruction that was erroneous as part of his alternate request. It was not, okay, that takes care of everything. There's nothing in this Court's jurisprudence on preservation that you need to come up with multiple different scenarios.
Now, Mr. Kuiper's point, though, is that you said don't charge initial aggressor. And the judge said, I'm going to. That's the only thing that was in front of the appellate division.
Correct. And the appellate division, of course, found it was preserved. And that's exactly what we're arguing here, that no initial aggressor language should have been given at all.
That's the only thing we should be deciding, not Melendez, not anything like that.
Well, that's all taken up within, because Melendez, the objection as to why it's confusing is based on an explanation of New York law as articulated in Melendez.
Well, the idea is that the charge has to be precise enough to convey what needs to be conveyed about the law.
That's absolutely this Court's.
That's your argument, isn't it?
That's absolutely this Court's jurisprudence in CPL 300-10-2. So when my learned opponent says, the jury could have figured it out in there, it's the trial judge's obligation to give them that clear instruction that he says so eloquently in his brief at page 12, the intervener cannot be the initial aggressor. The jury was never told that.
You get the impression when you look at all the facts that at some point when when Simmons is getting rolled off the porch, I mean, conceivably they could say at that point when he jumped in and further beat the guy that he was an aggressor.
Most of the prosecution witnesses, Judge, said that Mr. Walker did not kick at all, had nothing to do with the kicking.
But he was part of the after scene, so to speak, after the initial fight on the porch.
But the stabbing that we say is the justified defense of another had already occurred. So that's what he's charged with there. And by the way, not to be a
finish off, go ahead.
Yes, Your Honor. The people are the ones that really wanted this instruction because it dovetails with their acting in concert theory. Why do they need that theory when Mr. Walker admits he's the one that did the stabbing? Absolutely to eliminate and to use the initial aggressor to defeat the justification defense.
Thank you,
Your Honor.
both. Appreciate it.